I want to start off by being very clear about what the current test for standing is in Australia. It has two distinct requirements, either one of which, if you meet, you have the right to sue other of the party in court. Either you have to be directly impacted by something, like if I were to go and punch someone, they can sue me in a court, or you have to have a sufficiently evident and tangible interest in a certain law and its constitutionality, which is the case of anti-homosexuality laws in Tasmania, for instance. But the problem with that is that that legal framework relies upon a concept of tangibility and connection that is extraordinarily difficult to prove in some of the most important cases in Australia. It's the reason that Aboriginal and Torres Strait Islander communities cannot sue the government for historical injustices perpetrated against those communities, because they cannot prove a tangible link between their present-day suffering and the ancestral links to people who are related to them who suffered in the past. It's the reason that individuals who breathe in the smoke that is created by factories in rural Australia cannot sue those companies for breaches of Australian environmental law, because they do not have adequate standing and the courts do not take that as being adequate to prove a sufficient connection. First, I want to be clear about what our model is. First, we implement a standard legislative framework that allows individuals to sue courts via a system of open standing, which means that within certain limitations, like maintaining the ones about whether or not litigation is vexatious, we would allow individuals to sue in court regardless of whether or not they possess a sufficient connection, as is the case under the status quo. Secondly, we imagine that where, for instance, you sue on the behalf of a victim, the costs awards would go substantially to the victim, and courts would be able to divide that up in the same way that they're able to divide cost orders between multiple plaintiffs under the status quo. And thirdly, we think that where suing on the behalf of someone else, you would have to get the consent of that third party, which is relatively straightforward. So, the first question I want to ask is, why is the current system of closed standing unfair? The first reason is for the reason that people are affected by issues that occur to them at a general level that is very difficult for a court to adequately gauge. So, the clearest example of this is breaches of environmental law, in which it is very difficult to draw the dividing line between where an individual is sufficiently affected by, for instance, pollution that is emitted by a factory, and where they are not. For the reason that often, with respect to some of the most important issues that exist in Australia, the dividing line between whether you are sufficiently physically affected by a certain act and whether you are not is one that is difficult to draw. The question, but it is unquestionably the case that individuals are affected at some deep and meaningful level. So the fact that, for instance, logging occurs on the other side of Australia still affects me as an individual with an investment in the ongoing environmental heritage of Australia, because that not only contributes to kind of heritage, but also for the reason that it contributes to Australia's long-term sustainability and the lack of pollution in that country. And that is a sufficient interest that courts currently cannot recognise for the reason that they require a direct physical, tangible impact. The second reason, and more importantly, is that individuals have a democratic right to challenge legislation that they believe is unconstitutional, for the reason that we elect individuals on the basis that there is a sufficient limitation on their power. It's the reason that we defer democratic power from individuals to representatives, because we trust that the legislation that they implement will be within the specific bounds of the Constitution, so that we have some envisagement of what that legislation might look like, which means that because it is promised on those notions of restrictions of power, all individuals have a sufficient interest in whether or not laws are constitutional, but the problem with the system of closed standing is that it requires a specific interest that the court can identify, which is very difficult to establish in many instances. And that is the reason that very few challenges to refugee policy have been brought before the High Court, even though those policies are likely unconstitutional, for the reason that the people that could meaningfully challenge that legislation are located in refugee camps overseas. So all individuals have an investment in the maintenance of not only the Constitution, but also in the types of laws that are enacted by the power of that Constitution, and it's not sufficient for a system of closed standing to restrict the types of individuals that are able to sue in a court of law to a certain subset. The final thing to note is that We think that the status quo burdens individuals unfairly because of their lack of access. We ought not place the burden upon specific individuals to bring their claims to court if they happen, for instance, to be the only individuals who have the legal standing under the current status quo to bring that system to court, either because often they are in their own positions of disadvantage, like, for instance, individuals who are affected by environmental degradation are often also disproportionately poor or oftentimes poor and lack of resources or access to justice to engage meaningfully in the legal system. And that is a reason to suggest that, that the system of open standing would be better, for the reason that, under the status quo, you are disincentivized from bringing claims on the behalf of other parties, for the reason that those parties maintain the legal liability for costs orders, which means that even where they would like to sue, they are overwhelmingly unlikely to do that, for the reason that they still maintain personal liability for any costs made against them if they lose, which, if they are disadvantaged, they are likely to because they can't afford good lawyers, whereas law firms now absorb those costs and make it a lot less risky, and for the reason that often funding is limited to people who are legally disadvantaged anyway. Secondly, on benefits, first is some pre-rebuttal as to why this would not lead to an influx of vexatious litigation. There are lots of reasons to suggest that wouldn't be the case, like lawyers not wanting to do it because it breaches their legal professional responsibility, like the fact that it means that they are subject to cost orders if they lose, which they are likely to if the litigation is vexatious because it's time-consuming, and also because judges can obviously throw out claims that are bad. So, what are the benefits? The first and most important is that it allows for the enforcement of laws that currently do not get enforced. So one of the reasons that that laws are not currently enforced is because corporations are either able to buy out individuals to prevent them from suing that have the standing to sue, or those individuals are prevented from suing. And the fact that a corporation wields the power to determine whether or not a court case goes ahead is inherently harmful, for the reason that even if that individual does not have the right to sue, it is arbitrary that they happen to be the one that is given legal standing under the status quo, when in fact, as I've already proven, all individuals are generally affected by the types of policies that corporations implement. Secondly, for the reason that often governments do not enforce crimes themselves, for the reason that they have few incentives to, like they don't enforce environmental policies for the reason that they need to attract investment and need to build factories, and for the reason that people often themselves who are interested cannot bring claims because they don't have standing under the status quo, and that is harmful for the reason that it means that policies that are implemented via, for instance, electoral promises do not actually get implemented in reality, and this is an important form of accountability for those governments. Thirdly, for the reason that where due to historical disadvantage, it's difficult to prove that you have a sufficient link to, for instance, your ancestors. If you're an Aboriginal person, you cannot sue for historical injustices. And finally, where laws are unevenly enforced, like racist police discrimination, you can bring claims under the Racial Discrimination Act, where in a system of open standing, where you cannot previously, because under the status quo, you need to prove that you individually have suffered discrimination, which is difficult to prove because you only have access to your own case. But in a system of open standing, you can sue on the behalf of all individuals in the society, even if you don't have to plead to them. That's what it is.
The devastating implications of immediately conceding that the primary effect of this policy is going to be the enforcement of previously unenforceable laws is that very quickly 3 million illegal immigrants in the United States will have suits brought against them by organisations who protest undocumented immigrants, by the vast number of people who are constantly non-prosecuted for low-level drug consumption or dealing when identified will then be sued. Victimless crimes often go unenforced because they're not that bad, but some people very, very badly want to enforce them. And if what you want to do is instead bankrupt the people that commit them because the legal system or the legislature has not been fast enough in protecting them and fixing those laws, that is a horrific outcome. And that is the problem with the thing that their case identifies. literally every example that they use is on one side, when it is powerful people who have the power to curtail the government not being sued. But in reality, the vast majority of prosecutorial discretion is used, and the vast majority of times in which stuff is not bothered to be enforced, is when it is people who are very poor and very vulnerable, and the consequences would be catastrophic. Some people ideologically want to see them sued. I want to briefly just articulate the problem with all of their examples. The first one is the idea about how Indigenous people aren't able to get their lands back for historical wrong. Well, potentially the statute of limitations has expired there, which might be a problem. Secondly, it's really unclear what law company is going to take this up pro bono, suing the government, giving them an enormous political loss, and compromising all future suits that they might be able to get with the government. Thirdly, the problem that they identify, which is that it is difficult to identify who is the person who deserves the land, will equally mean that they can't get the land back when you're deciding who to give it to, because Kevin still said that he wanted to give it to the victim, and he needs to do it with the victim's consent. But given that the problem is apparently that we can't identify who the victim is in order to prove legal standing, it's unclear how they get their land back. So all you would do is take the land from the government and then give it to no one. Unclear how that mechanism plays out. The second thing they describe are environmental crimes. Well, firstly, you can use class action lawsuits for that. Secondly, those are often criminal matters, and the reason that they're not enforced is because the law is often very vague in that area. Corporations are incredibly powerful, and they have an enormous interest in not pursuing those things. Realistically, it's unclear how that changes when a group of people who are like activists who care very deeply, like they're going to form a class action and then they're just going to get fucking annihilated by their opposition. All that you've done is waste a small amount of time in court. The third thing that we hear is the idea of challenges to constitutionality. The one example that we get is the idea of challenges to asylum seekers, but the problem with that obviously is that those laws have already had suits brought for them because there are people who very clearly do have a clear interest, like the families of asylum seekers who live here and people live on manors, which is why there have been legal challenges to that, and Kevin's assertion is obviously in the shitter. And the final idea is just this absurd characterization that crimes committed against poor people at the moment don't have anything enforced against them, but somehow, if like what? Like if Clayton Utes is able to do it, and critically, Clayton Utes could just agree to take it on pro bono, presumably. And it's unclear why the thing that needs to be taken away is Clayton Utes having the standing instead of the poor person who goes to Clayton Utes. Like totally unclear how that mechanism played out. But critically, also notice that all of those examples are about rich people having this used against them. The far more plausible characterization is that rich people will use this in the way they conventionally use the legal system, which is to flood it with a ton of difficult and vexatious litigation, which obviously happens in spite of all of the structural reasons that Kevin wanted to point to, because the law is very complex and the line of what is vexatious is drawn a long way before the line of whether or not you're actually guilty. So realistically, that characterization was just devastatingly ineffective for them. Let's begin by talking about prosecutorial discretion and how it plays out. The thing to say there is that it is almost always about victimless crimes. And we had a couple of mechanisms there, but Kevin just concedes it for us. When something is victimless, now an advocacy group is able to go out and charge. Now you are able to bankrupt or potentially get an enforcement order against an illegal immigrant. And it's going to be very easy, because very often in these victimless crimes, the reason that they're not prosecuted is because, like, the cops know that it's a bad idea to do it, and they don't really want to enforce that law, or the government has decided that it's something that should be ignored, for instance with the DREAM Act, or something like that. But there's usually no doubt about the criminality of what has occurred, or the harm of what, or like the illegal nature of what has occurred. It's just prosecutorial discretion that's standing between them and getting deported, or getting bankrupted by a fine for a low-level drug offence that no one individually was harmed by, but is still likely to be devastating, or a protester being sued by the kind of person that they are protesting because they committed some crime that governments conventionally don't take them to court for, but corporations very trivially have a clear interest in taking out these actions even when they're not necessarily able to pursue them in a court ordinarily. Corporations clearly have big interests in doing that. And that's the problem here. All of the things that they describe are very complex cases that are unlikely to be successful, that are likely to take a very long time and clog up the courts. But the things that we describe, there's really no doubt. Prosecutorial discretion is the only thing that was standing in the way previously. Now, advocacy groups that want to harm those people are able to just get them through like that, you know? It'll just be a churning line of deportations and bankruptcies for low-level drug offences and things like that. That is a horrible outcome in this debate. I now want to look to how corporations are going to be able to effectively bully people in this debate. So the basic thing to say here is that the rich will obviously have radically more access to this, because most people do not have the sufficient chunk of change to challenge the Australian federal government on constitutional law. Rich people do. They have that chunk of change many times over. So do large corporations. Expanding the legal power of large corporations to intrude upon things that are not their business because there is no obvious victim there is no obvious victim out there, gives them the capacity to do other things. For instance, if you are negotiating with someone and you want to coerce them into a particular outcome, you'll be able to make it very clear to them that you will bankrupt them. Previously, you didn't have that avenue because, say, you were never associated before with them. But now you can look to any incident in their past in which there might have been someone who lost money, or in which everyone in the community lost a little bit or anything like that. And critically, they said there's going to be no vexatious litigation. As I've identified, that is trivially implausible because there is currently an awful lot of vexatious lawsuits, and it's unclear how their protections aren't operating for those who would operate in these circumstances, which means that the person doesn't even need to do anything wrong for you to threaten to bankrupt them, because the law is incredibly complex and you need to hire a pretty fucking good lawyer to get off when Enron is the one suing you, or when a property developer wants to blackmail you into moving out of the area. And yes, there might be some evidence of vexatiousness, but again, realistically, they're likely to become corporate specialists who make it their interest in ensuring that these things are very easy to do, which very quickly means that problem is going to be erased there. The harms from that are very simple. Firstly, some people are going to lose an awful lot of money or have things enforced against them unjustly, because now there is an additional avenue for corporations to take people that they want to blackmail and make their lives worse. Secondly, you lose rights because you are able to have things enforced against you in a way that is enormously damaging because a corporation wants it to be that way. If you need to clear out of your land, if you need to give a public endorsement of something, if you need to let up on some other lawsuit, if you need to give someone access to something like that, it's very easy to blackmail individuals and smaller actors in the way that already increasingly happens. Large corporations all the time, if they've had prior associations, threaten to countersue if you're considering suing, or threaten to use legal actions as parts of complex negotiations. Expanding their power only expands the scope for damage from that. The final thing that I briefly want to describe in this debate is why principally this is immoral. The essential thing to say here is that the government is a pretty good actor when we're talking about laws, because it represents everyone. So they kind of have legitimate standing in the sense that things that happen in the community are very clearly their domain. And individuals have a very clear interest and right to be participants in the legal process because the thing happens to them, so it's something that's sort of relevant. The question that this debate begs is, what moral right do we have to enlist the services of the legal system on behalf of people who have nothing to do with the case? It's unclear morally why the use of state power that is not absolute in right, as Kevin correctly notes, should be enforced in this way. This will be catastrophic to people who have very easy legal suits against them, who at the moment the community refuses to enforce, but will definitely start doing when rich advocacy groups are willing to do that on their behalf. I'm so proud to oppose this motion.
When Beach made this debate largely about victimless crimes such as drug dealing or illegal immigration, it was really unstrategic because the only person who can take you to court for the crime is the state. And this debate is actually about civil cases. And there is no civil suit for being an illegal immigrant. There's no civil suit for being a drug dealer, and to the extent that there is, it's about the general harm your community faces when being overrun by drugs and the associated harms, or maybe gangs, and maybe people should be able to get redress from that. But for the large extent of it, victimless crimes, by the word crimes, are not part of this. And that's why the fact that we hear no response on what I believe is genuinely debate-winning material about how this could be the only way to enforce environmental regulations and save the planet is far more important, because it is actually the content of the debate and it is actually about civil stuff. First, on the practical outcomes of this. The first thing I want to talk about is whether or not over-litigation is likely, because they rest their case on, well, maybe people are going to do vexatious claims left, right, and centre. There's a few reasons to expect that this is not true. For the average person, it's definitely not true because of cost and time, and also because judges can throw out a case if there is not sufficient evidence in it in the first place. So, for example, even if you do research into me and find out that I may have harmed someone sometime in the past, there's genuinely, even though I've been an equally bad person as the average person, genuinely no way to find enough evidence for that. That's why it's really hard for them to argue that over-litigation is unlikely. And even though they might claim to you, well, corporations don't care about insane costs. They don't care about claiming or wasting all of their time. It is just obviously true that they do. There's no reason to expect that people would waste their money in this way when they cannot prove these kinds of claims. Over-litigation is probably a poor way of them getting the outcomes that they want. when it comes to victimless crimes or over-enforcing the laws, we think that there's two observations to be made. First, it is untrue that the under-enforcement of the law at the moment benefits minorities. In the case where we have drug laws that are only partially enforced, this is always done in a way that is skewed towards majority, right? That is pulling over way more black people than white people. It's stop and frisk, right? And that's why we think that if it is true that we can now enforce these laws to their full capacity, one, at least that is fair, and two, this means that it's likely that these laws are changed because they're bad, right? And the government is only going to have the political capital to do that when white marijuana smokers also end up losing their money. But obviously, it's not really about drugs, and that was pretty generous of me to even spend that much time on. The next thing to say is, they're like, in terms of things like asylum seeker policy, they really make a flippant response, which is, why can't the families of asylum seekers who live in Australia, or people here who are asylum seekers who have gotten through the detention process, just make these claims? One, they can only make the claim to the extent of the harm on them, which is not sufficient. They are unable to make those constitutional claims because of the limits we tell you of cost, of time, of expertise, or maybe of willingness to take this up all on their own and to potentially bear a cost order. And that's why, and maybe it's true that in the case of refugees, there might be a guy here in Australia who's willing to do it, but it is an example of a concept which still stands true, which is that in the case where there is a party who has an unconstitutional law against them, and they, because of the nature of that unconstitutional law, are excluded from Australia, we do think there should be redress from other people in Australia. Importantly, what they're claiming here is, obviously law firms currently take on cases already. Why is it important that they have the standing themselves? And this is probably pretty key. Kevin says it, it's because then the cost order accrues to the law firm rather than to the individual, and that's why it's better under our side. Because if a refugee's case is taken on the standing of a law firm, and they lose, which sometimes happens, then it is not the refugee who incurs those costs, it is the law firm, which makes that claim, yes, more likely, but also less scary. I already said why I thought the environmental law stuff was debate-winning. All they claim here is that these are very complex cases, and that they're very hard to enforce, and that perhaps it is unlikely that it will happen in all of the cases. Firstly, it is more likely to happen when we do not have these bars that you have to jump, these further hoops and hurdles you have to go through. Secondly, even if it only happens once or twice, the enforcement environmental law has the potential to be so incredibly beneficial for society that I think it is, I've already said what I think it is. And thirdly, I think that it is just untrue that these have to be overly complex cases. Sometimes things are just, on the face of it, pretty unconstitutional looking, and that the only reason we cannot do anything about it, even though we would win, is because of this standing. They haven't addressed that. Their last and I think most interesting point was about corporations using this to blackmail people, i.e. the actual definition of a vexatious claim. So when they said the line of what is vexatious is so blurry, well, not in those cases, right? Those are the ones where it's pretty clear. And even if you could skirt around them, firstly, it's likely to be on corporations against other corporations rather than on individuals, which means, I don't know, maybe you still care, but I've stopped caring at that point. Secondly, that it's unlikely that they are actually able to do this for the reason of the evidence that I told you earlier. Like, if you can find and get 1 million PIs on my case as well, but it's not actually going to be useful to you. Corporations have plenty of other ways to be evil, and this is not going to be the one that they take up. So at the end of this issue, what we see is this is going to be practically incredibly helpful in enforcing laws. And even if it sometimes enforces laws against those that are worse off, the actual people who are protected by this are those that are best off, who claim that because they can spread their harm thin and wide, that they do not have any claims against them. That is why I think we've won the debate in multiple ways for refugees, for Aboriginal people, and for the environment in this issue. And then on to whether it is principally unjust. And
This, I think, we have proved at Heaven and heard very little in response to. We gave 3 reasons why it is principally unjust that the standing thing even exists in the first place. Firstly, we said generalized harm is no less harmful than a specific harm. We secondly said that you have a democratic right no matter whether a policy harms you, because the point of the Constitution is to protect you, and if something is unconstitutional, you have the right to say so. And thirdly, we said it harms access. And all of these things have very little principal response from Beach. Importantly, the only thing Beach does is somewhat mock us, because in some of these cases there is a victim and in some of these cases there isn't. So for example, in the case of taking on a case from a poor person, yes, we would need their consent. In the case of taking on a crime for all of Aboriginal people, no, we wouldn't get one Aboriginal person to sign the paper. No, we wouldn't get one person to sign the paper on environmental laws. They were clearly on 2 different cases. This doesn't make our model doesn't make this unenforceable at all. It is clear that people have a principal right here to make cases about things which affect them either generally or affect the state of the world, and that standing is a hurdle which they shouldn't have to cover in civil cases, and considering that this wasn't about criminal cases, we're far ahead at this point.
The thing is, different people can be upset by different things. So whereas some people might be upset by logging on the other side of Australia and think that that gives them a principled right to fight against that because they think that is like within their constitutional rights, other people might think it is within their constitutional rights to fight against an influx of illegal immigrants that they are opposed to. We think that there is very much a case, and it wasn't enough for AFT to be like, oh, like you just can't make a case against illegal immigrants, so that won't be a stakeholders debate. To the extent that you defend that you can make like huge prosecutions for like logging companies and being offended by like drug crime in your community, you also have to defend people who are offended by the existence of illegal immigrants and defend the cases that are inevitably going to be put in prosecuting those people who are more vulnerable and will lose out in that case. So, that said, 3 questions in this speech. Firstly, what kind of things are realistically going to be prosecuted in a world with an open standing? Secondly, what this does to like powers for like different groups or like corporations, for example, being given more or less power than the comparative. And thirdly, what this does for victims, which was not responded to enough in Eden's speech. So first, on what are some things that they want prosecuted. Ideally, the Affirmative wants us to prosecute things like the mistreatment of Indigenous people, the environmental and logging things that don't necessarily affect you because you're on the other side of Australia that might affect you long term, but also like things like mistreated asylum seekers. I think Beach did a pretty good job of telling you why all of these were very unrealistic cases that would not work out in favour of the group, of like the progressive but less political capital group. So, in terms of Indigenous past mistreatment, 1, we tell you the statute of limitations makes that very unlikely. 2, we tell you that there is an unclear defendant and an unclear victim, which makes it very difficult for any outcome to come as a result of that case. And 3, just in terms of political capital, the victim in that situation is far less powerful than the state or like the corporation or whoever you want to name as your defendant, which means that is unlikely to be a successful prosecution, and therefore it is not a benefit that you can necessarily claim on your side. In terms of environment and logging, we tell you 1, it is in the public interest. If you can prove it is in the public interest, then it is not relevant to this debate, because this debate is about interest, like situations that have not been deemed by the DPP to be in the public interest. So to the extent that something is in the pressing public interest, it is not relevant to this debate. But secondly, again, you're likely to lose that case to a powerful corporation if that powerful corporation is the one that is doing that logging. They're the ones going to have access to more political representation, more political capital, more legal capital and stuff like that. That was going to mean that they were going to win that case, and you didn't get that benefit either. Thirdly, in terms of mistreated asylum seekers, we want you to firstly be comparative with the analysis we brought you about asylum seekers and why they are far more likely to be victimised by powerful people who oppose their existence in the community. But secondly, also, like, we can have organisations act pro bono and absolve those victims' costs too. I'll deal with that more in my issue about victims. We don't think you necessarily claim that benefit or get any constitutional change for them either. So what did we tell you were the kind of policies we were, the kind of cases we were more likely to see prosecuted in a world with open standing? We told you that these are going to be targeted at vulnerable people who are less likely to be able to represent themselves legally. There was people like the illegal immigrants, like the dreamers in America. It was also like low-level drug crimes or things that would usually be like that are swept up, like disregarded by the DPP because they don't consider them a priority, but might be considered by some like conservative white person in that community to be a priority to them, and therefore they push them through a private law firm. But also, we thought it looked like corporations using any law they can get their hands on to prosecute people like protesters who are disadvantaging or providing a threat to their business. We thought that was really bad because those corporations had a disproportionate number of power that meant they were very likely to win those court cases. I'll deal with that more in my second issue. What do they tell us on ACT though? They say that they're going to disregard all that because this debate is exclusively about civil cases, and so we can't talk about illegal immigrants or people, and it's just about people who have like a right to be upset about things like drug crime in their immediate community. We tell you, as I told you in my introduction, that this is a huge tension in their case, because if they say that you have a right to be threatened by things in your community that you deem like in violation of legislation, for example, drug crime, you therefore have to defend that they are going to prosecute people in a racist way, given that like a lot of people operate like in the way they deal with drug crime now in a racist way, in that like disproportionately people of colour are affected by drug laws. That gets worse when you allow literally any white conservative person to take that person to court and prosecute them. And the same applies to like racist people doing the same for illegal immigrants, because they can also make a case of being threatened by the existence of those people in their community. So that's what the kind of cases look like, and that's why you were always going to give more power to people who had more political capital, or more likely to be like the privileged ones that benefited, and you made things so much worse for vulnerable groups. Now let's talk more about what that disproportionate power looks like and what the harms of that are. They make a concession, a really important concession at first, that corporations have the power and incentives to manipulate legal processes and structures as they exist now. We think that is very true, and something that gets a lot worse in our side of the debate. So we tell you that corporations can use this as blackmail for, like, for example, protesters who are threatening their business. We also think they can use it for like low-level workers in their company. If they get any dirt on that worker's past, they can use it to threaten or coerce that worker into doing things with the threat that even though they were not a direct victim of that crime, they can prosecute them now, and therefore that gives them more manipulative power. We think that that provides a huge deterrent for anybody ever like protesting against those companies or doing anything to like threaten those companies, which gives that company disproportionate power in a way that is really bad. But it also means that in the event that they do take that to court, they are always going to win those battles because they just have this, they just have more capital and stuff like that. Next, we tell you that you incentivize things like police not arresting like nice-looking kids. So, for example, police now know the implications of arresting someone and giving them any kind of record. That is bad because police already operate on racist incentives. You see that with like disproportionate incarceration rates and stuff like that. That means that if a police person sees, for example, a white person doing drugs, they know that if they are to arrest that kid, that is going to make that kid have the danger of being prosecuted in the future by someone else. They're more likely to be like, I don't want to like make that happen to that white kid because they look like a good kid, otherwise I'll just let that slide. They're less likely to let it slide for black kids because they have those racist assumptions about black people, think they are less like that they are less productive members of society and are more likely to arrest them in a way that will really disadvantage them later in life in the instance that they do get prosecuted by a random third party. And I already dealt with the stuff about dreamers. So what does ACT tell us in response to that? They say that, or what does ACT tell us is the benefit of power balances? They say that this is really good in combating that power that corporations have because laws that currently aren't being enforced can now be enforced. This is in the assumption that corporations somehow magically stop being able to coerce different groups once there's a process where anybody could prosecute them. One, it doesn't matter whether it's the DPP or the government prosecuting or whether it's an individual prosecuting, we still think the corporation has the same manipulative power. So to the extent the corporation can manipulate government policy now, they're probably more able to manipulate an individual who is prosecuting that corporation than they are the government. But secondly, they're more, like we told you, they're more likely to look at enforcing laws against vulnerable people who can't protect themselves. That looks like the black kid smoking marijuana over the white kid. That was bad. Here's where I'm going to integrate some substantive though about how this makes things so much worse in that power disparity in the legal system. Because when law firms are now able to prosecute, as they are not now, the DPP, the Department of Public Prosecution, gets significantly weaker. Why is that? Because any expert or well-trained prosecutors that exist in the DPP now have a financial incentive to go and work for private law firms where they will get a competitive rate, get paid a lot more, and like be able to do a lot more than just offer like vague advice. So now you have like a mass exodus of anybody who has any good training or expertise on prosecution leaving the DPP and going to work for private law firms. What did that mean? One, it meant that private law firms got significantly better and their prosecutions were more likely to be successful. That was important because it was the most wealthy private law firms were going to be representing the most wealthy clients. But second, and you entrenched the disparity, the wealth disparity within the legal system. But secondly, the public prosecution department got significantly worse because they lost all their expertise. That meant that they had to give all their public prosecution trials to like younger, less experienced prosecutors, which meant that those cases were going to be less successful, and that was the case for any kind of public prosecution that happened, not just civil cases, but like any terrible crime that happened, public prosecutors were going to be less well trained trained and therefore less equipped to deal with that. So because the power disparity was made so much worse when you gave corporations unlimited power in prosecuting whoever they wanted, whenever they wanted, they always had the most political capital. This debate is so proud to stand in opposition. Let's start this speech with a clarification that we gave and needed but wasn't responded to, but is crucial to this debate, which is that standing does not apply in criminal cases. The state assumes the responsibility. That means we are only talking about civil wrongs in this case. That's important for two reasons. Firstly, any else about things like statute of limitations, etc. falls out because often they do not exist for civil wrongs, they often only exist in the case of crimes. Secondly though, at best, that means that when you're talking about something like migration or illegal migrants, given that it's not a civil wrong to be an illegal migrant, but it is a crime, you cannot sue someone in civil court for it. At best, on their side, what you can sue for is you can sue the government for non-enforcement of migration laws, but that doesn't affect individual migrants directly because you cannot take those people to court. That means there is no difference between the type of crackdowns we already see the US government doing and our policy, which we continue to support. It also means that all of the material we get at second about the DPP and prosecutors falls out because we are not dealing with crimes, we are only dealing with civil wrongs. You need to engage with what the debate is actually about. Maybe you'll do it in like the last 8 minutes. Two questions in this speech. Firstly, on the principle, which I'll note was profoundly unresponded to, and secondly, on all of the benefits that we give you. Let's reiterate the three principal claims we give you, which get absolutely no response, so that maybe we do get a response at third. Firstly, we tell you that people are affected by issues at the general level, even if not at the specific level which is required to bring standing in a civil case in Australia at present. We tell you it's worthwhile that those people have those interests represented. We say specifically that is things like the non-enforcement of environmental regulations currently, which affect everyone, even if it is the case that you are not the specific person whose farm is affected by climate change, you still experience some consequence. Secondly, we tell you this is a fundamental extension of your democratic right to make sure the government is enforcing policies that you voted for and not acting against your democratic wish, because it is the only means by which you can constitutionally challenge the validity of laws, and that if you do not have standing, you are unable to fundamentally do that, which we think is a democratic right all people have. Finally, we tell you it is unfair to burden some people and only those with standing with the obligation to bring a claim or see it go unfounded, and that is to say that it is unfair that it is only if you are the person who is directly affected by an environmental crime that you should have to bear entire responsibility for making sure that wrong is righted. That is also something that they don't engage with. We think we have so clearly won this principle because anything that comes out now is just like probably a bit too late and unfair. Second question in this speech though, what does this do in terms of impacts? I'm going to start with Arth claims about whether it is likely that these claims succeed. Secondly, I'm going to talk about poor people and migrants, and actually, yeah, I meant everyone else. There's just like so many people. Firstly, on whether it's likely that these claims succeed. They tell you these claims will not succeed. The first thing I note is this is largely assertive and under-explained. What analysis do we get? Firstly, they tell you things like the statute of limitations, and I noted previously they often apply to crimes more than they apply to things like civil wrongs, which means that it is likely in lots of cases you can continue to bring these claims irrespective of that particular date. The second thing to note is that often the statute of limitations is quite large, which means that even where it does exist in civil wrongs cases, it's still likely you can bring a claim. And that's things like, limitations on things like assault being like 12 years in length. That is a good period of time for people to bring a claim. If we're talking about things that have happened historically, we think that often in many cases you can still work around those statute of limitations because it is not only one type of civil wrong that you are claiming for, but often many, such as things like ongoing discrimination or non-enforcement of laws that deal with discrimination which do not have a statute of limitation in of themselves. Secondly, they say, well, often they don't have political capital. That is the exact reason you need to have open standing, so that people who do have the political capital can bring those claims on behalf of those people. Like, if political capital is the problem you're concerned with, you relegate those people to being stuck in that position under your side of the house and provide no solution. Finally, they tell you, well, often it's difficult to identify a defendant and identify a victim. Obviously, though, it is comparatively better that in cases where we can do that, they get some form of action as opposed to the total absence of action you get under your side of the house. So you need to be comparative, that even if it's not true our system is perfect, it's substantially better than the alternative that you guys offer, which is absolutely nothing. I think the final thing to note, though, is that you need to be comparative, right? Because under your side of the house, you restrict access only to those people who have the political capital. That is likely the people who are most privileged, the type of people that you say this is most wrong for. On our side, you expand that by allowing other people to bring claims for them in a way that is important. We told you why it was that things like costs in particular meant that even if you offered things pro bono, that probably wasn't sufficient. We didn't get any response to that material that already came out. Secondly, on poor people and migrants, So they say here, well, you know, you can have things done pro bono, so that means that you get sufficient results anyway. We already told you down the bench why it was that given you have personal liability for costs, even at the point that you do pro bono work, that's often not sufficient to get around the cost barrier because cost awards can be significantly large. But I think secondly, importantly, even if they skirt around that important aspect of the law, right, you are less likely to take on risky cases pro bono, or importantly, cases where there is not a huge amount of money to be won at the end of them, and that means that often some of the most important issues go unlitigated. That things like refugee rights, which you are correct, are often difficult to prove, but it is worthwhile litigating them regardless, or things like environmental damage, which often do not have large payouts from which a law firm can benefit, but have huge net societal claims and benefits that people want to necessarily get the benefits from. That's important because you didn't engage with that capacity in it. On migrants, I have 3 responses to like the weird American claim. I think the first thing is, I already told you these are often not civil wrongs, which means you couldn't sue for them. Secondly, if you can only sue the government, so individuals are unlikely to be affected, and given the crackdown that already happens in the US with these types of policies, it's unlikely to make a material difference. The final response is, I think it's fair to say this debate happens in Australia by virtue of the motion explicitly referencing the standing requirements of Australia and not other states. At no point in our case did we say that it applied internationally. Kevin referenced Australia's specific requirements. I think it's fair to say that falls out of the debate, even if my earlier responses don't already sufficiently rebut it. Let's deal with asylum seekers, or actually no, let's deal with corporations. That seems important. They say corporations can blackmail you and buy you out. I think, firstly, obviously, as Aidan points out, this is the definition of vexatious litigation, so it doesn't equate to anything if you make that blackmail threat anyway. Secondly, blackmail is a crime, and lots of people know that, so it means that even if the perception that you can be blackmailed is enough, it's probably not enough for everyone to be blackmailed into things they don't want to do. Finally, you need the consent of the victim, which would be a known fact, which means it would be hard to make just vexatious claims on that basis. And finally, you have to be comparative, because you've talked about the enormous buying out capacity that corporations already have. That still exists under our side of the house as well, and exists under your side as well. What that means, you have to ask the question is, does it get so much worse than already exists that it is worth justifying the loss of all the benefits we bring you? We didn't get any response or justification as to why that was the case. Importantly, that means when you talk about things like protesters getting blackmailed, protesters don't have to protest anymore because they can now literally sue you in court. So even at the point that you do get blackmailed, it seems relatively inconsequential. Finally then, on asylum seekers and white kids not getting charged, we hear it second that, you know, like, now there's no incentive to charge white kids with a crime. Like, first of all, we're not dealing with prosecution, so it is wholly irrelevant on that particular basis. At best, you could sue for, like, non-enforcement. But I think the second thing to note is, like, that already happens under the status quo, see, racism, sexism, etc. So we just think, like, there's no net material difference in that particular instance. Anyway, the final thing to note is it actually gets better because now you can sue the police for non-enforcement of the law at the point that they do not charge white people with the same crimes they would charge black people for, because that is a civil wrong definitionally in not enforcing what the law actually is. That seems necessarily better. Finally, on asylum seekers and constitutional issues, they give literally no response to the democratic principle that we give you. I'll give you another example that is not asylum seekers, given their only response is to say they already get that protection. Things like the school chaplaincy program, which are constitutionally invalid or have been held to be constitutionally invalid, go unchallenged because people do not have adequate standing to challenge those programs. We think it's important that issues like that are discussed as to whether or not they're constitutional. Finally, on asylum seekers, I think that it's just like not true that they can sufficiently challenge the treatment they get, but even if it is true they are least able to do so, it's better that we would allow empowered people to do that. We are so proud to propose.
For a team that so emphatically constrained this debate to civil suits, so many of their harms seem to invent new civil suits. There is no civil wrong for there being smog in your city. There is no civil wrong for your river being a little bit dirtier than it otherwise would be. And so, in a way, this affirmative team concedes that this policy would have to have more power and more significance in its effects on people than they would like to claim. The second observation I have is that essentially the harm's way up in the debate is this. Their claim is there are some bad things which happen to the vulnerable and are perpetrated by the powerful, and those harms aren't prosecuted because they're essentially too vague and they might not have a specific victim. But there are many things that more powerful people think are bad that are also not prosecuted for exactly the same reason. So the question of this debate is which suits are more likely to be brought
and which suits are more likely to be won? Who has the economic largesse? Is it the fucking left-wing environmental hippie who wants to charge one of the biggest energy companies for polluting a river? Or is it the rich white Americans who don't want black people living around them because that constitutes the civil wrong of making their neighborhood more dangerous? Is it the people who do not want immigrants to live in their neighborhood for exactly the same reason? And that's the final response that I have in terms of the kind of the civil criminal law thing, is that if a person with standing can bring a tort against someone if any crime is committed against them, right? So, in their world, if someone commits any crime, you can bring a civil suit against them because of open standing. That is how it works. So there you go. Okay. So after that, it is fairly clear how the way up works, and it's fairly clear that the way they've attempted to define the debate to be convenient for them doesn't make sense. The first issue that I have is about fairness. Because they say that people should have autonomy, they should be able to challenge the legislation because, you know, after all, the government's meant to represent us. And people can do that in the status quo. When they vote for the people who write the legislation, and they vote for the people who choose what crimes are or are not prosecuted. They currently have that power. And yes, we might disagree with legislation sometimes. Yes, we might disagree with the way prosecutorial discretion is used sometimes, but that can change and society does progress. The question is, do we allow anyone to override those decisions? Most likely the powerful, and the answer is no. And if the affirmative team believes that this principled question is enough to win them the debate, then it is also conveniently enough to win us the debate. It is not we should not allow people to override the way in which prosecution is currently decided based on nothing. So we win. There you go. So, the next thing I am going to discuss in this speech is vexatious claims. Obviously, corporations and other wealthy actors have clear incentives to make vexation claims. It's very easy for them to hide that even in the status quo, so they can, for example, just hire a law firm and obscure the connection between them and that law firm. But it is now astonishingly easy to do that as a result of this policy, because anyone can sue no matter how distant from the crime or the harm they are. So the trail from the company that has an interest in prosecuting it, to the law firm that they hire, to eventually the harm that accrues, can be as distant as the corporations wanted it to be. So that is why, in their world uniquely, it is functionally impossible for judges to throw out cases on the suspicion that they're vexatious, because their policy empowers companies to hide that extremely easily. The only other claim that they have, well, they have two, is firstly that you still have to demonstrate some kind of harm, and this is true, but there are many types of harms. Protesters can be accused of all sorts of stuff. Destruction of the public peace, destruction of property, trespassing, all of those things are easy to launch as civil suits. The other response is that you need evidence. The first response is that you actually do not. Just a corporation sending a letter to the leader of a protest organization saying, I'm going to bring this to you if you don't fucking shut up, that's enough to frighten a whole lot of people, and because those people are adverse to fighting a very expensive legal battle. But secondly, obviously, again, that actually concedes our side of the house. If evidence is one of the requirements, who is going to be better at getting it? The corporations with the largesse and the connections and the lobby groups that can discover those things, or just people who happen to be moral people and support good causes? Obviously, it is the former panel. So, that is why vexation claims will happen far more on their side of the house. And let's be clear, that means, for instance, as we told you, activism against corporate actions becomes almost impossible. And Kaity's like, no, but now they can sue. Oh yeah, the fucking uni students who have $10 after they pay rent every week can sue. No, they can't. The vulnerable who have the incentive to protest are the ones who can access their power only by being visible in the public. They're not the ones who have access to power via having the money to do a legal suit, and that is why they disempower protest. So, on prosecuting, firstly, where's that fucking piece of paper? Oh, I lost it. I think I can remember it, maybe. Whatever. Oh, yeah, I think I can remember. Okay, so, on prosecuting individual cases, like on the behalf of the vulnerable. We told you that they could do this pro bono. They're like, well, the difference between that and this is that, well, the vulnerable party has to take the suit if they lose. But obviously that means legal firms are far less incentivized to take those cases because now if they lose, they cop an enormous risk. So in their world, those cases aren't taken at all. In our world, they're taken. Maybe the people who lose suffer a harm, but the people who win suffer a benefit, which is far better than on their side of the house. Now, on prosecuting dispersed harms. Obviously, as I said in my introduction, that goes symmetrically. There are some things perceived as harms that occur to privileged people and to disprivileged people, and more likely the former are going to be prosecuted. But in the cases that it's like a corporation putting smog onto there, those are the cases where they're likely to have excellent defenses. Firstly, because as I said, corporations have intense lobbying power, that means they've also lobbied environmental law to be too vague for them to be able to be prosecuted, which means that, you can bring a suit against them, but the corporations have fucking thought ahead, and it's not going to work anyway. And secondly, this is about standing, not about the significance of harm. So if you're like, I am bringing forth this case on the behalf of people because I cough sometimes when there's smog, it's true that you now have standing to bring that suit, but it's a dispersed harm which the court will not, it being open standing doesn't mean that the law cares any more about insignificant harms, is essentially what I'm saying. So all of those kind of like collective action problems, dispersed harms material makes no sense. So, at the end of this, the wealthy are going to be able to abuse it, the disprivileged aren't even going to be able to access it. We win quite clearly.
Well, this debate was quite awkward because it was a team of 4 law students via a team of 0 law students. But it was even more awkward because a team of 4 law students couldn't even decide if this was a debate about civil or criminal cases. Kevin got up and gave us like half of his harms about punishing crimes which didn't get punished, and then for the rest of the debate, we heard that actually those weren't part of the debate. But I think what this means is either they lose half of their benefits, or they let vulnerable people open to unfair criminal cases. But I think kind of at the end of this weird schmozzle about civil v criminal, the more embarrassing thing for this team of 4 law students is that they've totally failed to take into account how power structures impact the way people experience the law. Because it didn't matter if you were being subjected to a criminal case, if you were being sued or tried by someone who was far more powerful than you, who had a far greater amount of capital than you, that was equally problematic for you. So 2 questions in this reply. Firstly, who was more likely to be benefited or harmed in this debate? And then, like, the sort of minor principally thing. So, on the benefits and harms, what we hear from Aff is that it would be probable that vulnerable people would be suing governments and corporations. They thought they'd improve access to the law, and they thought they'd remove barriers to entry. As we pointed out at Bostan, the problem with this access argument is that it was premised on 2 contradictory ideas. The first being that firms would increase their pro bono work, and the second was that it became massively more expensive for them to do so. That seemed a little bit in tension. What we told you was that vulnerable people could do things like class action lawsuits, and this was probably a lot more accessible than individual cases. We gave you examples that they also wanted to use about things like the environment and people like refugees. The second thing we told you, and I think the more important thing, was that the people who were best at using civil law were rich, and this was presently true. We gave you lots of examples to that, which they didn't really respond to. But we also gave you structural reasons for that, which was that these people had access to good law firms. That meant they had excellent defences, they had more access to information and evidence against you, and they actually had a lot of power. That meant they could pressure victims and also the people that they were trying to blackmail or whatever. So essentially what their policy did was that it empowered like vexatious claims. It made them seem not vexatious, because what you did is you lowered the barrier of entry into the legal system. You made it easier for people. You made it easier for people to enter that. And I think this is important because a firm is a lot better at wearing costs than like a random protester, because a firm doesn't care if you sue it for $2 million if it's worth a hell of a lot more than that. But a protester is almost certainly not worth a couple of $1 million. So that means even if both teams have the same amount of civil cases on either side, it impacts the individual people a lot more, and that means on net, the opposition harms individual poor people a lot more. On the principle in this debate, I don't think it's that important, because I think if the law becomes massively less just in practical terms, maybe we don't care about the principle so much. But what did they tell us? They tell us that people care about the Constitution, and sometimes people have general suffering like breathing in smoke. We told you at Beach, and this never got a response, that government and the legal system should act in the interest of the public. That was the whole point of the law, and it was written to represent the public. This meant that discretion with regards to standing would generally be acting in the public interest. We noted that the government doesn't personally approve or disapprove of cases, and because it was largely used to filter problematic cases which, as a society, we decided didn't need to be treated in the court, it was probably fine for this discretion to exist because it was acting on behalf of society as a whole. So if the opposition cared about empowering society as a whole and their general sufferings and interest in the Constitution, then it was probably important to let the government or representatives of the government act in the public interest to ensure that individuals receive the maximum benefit from the legal system. Note that individuals received the maximum benefit from the legal system when they were less open to being attacked by groups of people or institutions with far more power than them, far more access to capital, and institutions and groups that under the opposition's model got even more powerful and had even fewer barriers in the way for them exploiting people who have far less power. So at the end of this debate, I think what we do is we protect the people who the opposition care about, but essentially want to sell out. Crowds for me.
Environmental legislation provides for civil wrongs, but the problem is that the government doesn't bring them to court. The Racial Discrimination Act also provides for civil wrong, but that same problem exists. We were the only side of the House that empowered people to engage with these civil wrongs, and because of that, we were the only side that could benefit those people. Two questions in this debate. Firstly, is this principally justified? And secondly, are the outcomes we produce good and beneficial? On to this first question. We told you 3 reasons regarding why current limitation is unfair. Firstly, it is difficult and unfair to draw the line where someone is sufficiently affected, and so we shouldn't. We heard no response from the opposition. Secondly, we told you that it was an extension of a democratic right to challenge the constitutionality of legislation. The only response we heard was most recently at third, suggesting that people can vote if they want this democratic right. We told you the difference was that this was an extension of that democratic right, and we proved to you right down the bench why that extension was warranted. We thirdly told you we shouldn't place a specific burden on specific individuals. Again, that wasn't responded to. This principal issue was important because if it was believed that people suffered harms within this debate, then they should principally have access to that recourse and to the legal system. We won that issue. But now onto the second and most important issue in this debate, about whether or not the outcomes we produced were actually practically good. The opposition told us 4 main things under this issue. Firstly, they told us that this would result in vexatious claims and over-litigation. We told you 6 things down the bench. Firstly, we told you that the type of issue they were talking about in regards to suing protesters could already happen regarding a disruption of the peace. But secondly, we told you it was very unlikely that related situations would actually happen. At first and second, we told you that was because it was an immense cost and time effort involved. We never heard a response to that. Then at second, we told you that a judge could read your statement of claim, and that would prevent vexatious claims from entering the courts. Thirdly, and this is in specific response to big companies that the opposition wanted to talk about, we again told you why big companies did have an incentive equally to not waste time and money at second. But secondly, we also told you at second that there was very little evidence that they could dig up about people if they were trying to make a vexatious claim. Fourthly, we told you at second that you needed the consent of the victim, and that made these claims a lot more unlikely. But lastly, at second, we told you, at third, we told you that the opposition needed to be comparative in this debate because bargaining power of these big companies would still exist on either side, and even if it was increased a little bit more, the opposition had to compare that harm to all of the benefits we provided you with. This was the opposition's strongest material, and it didn't stand at the end of the debate. Their second harm was an over-enforcement of laws, specifically related to drugs and immigrants. Firstly, we think a lot of this was kind of part of crime, and so it fell out of the debate, because we thought you couldn't bring a tort against someone within a victimless crime, but we still dealt with reasons why it wouldn't happen. We told you, secondly, that you wouldn't be directly suing the migrant, you would be suing the government, so the harms wouldn't accrue. We thirdly told you that this debate was happening in the realm of the Australian legal system. And lastly, we provided you with benefits to minorities, such as fair enforcement as second, as well as the fact that we would change these laws due to the capital because they were now enacted on rich white people. So the people that the opposition cared about most in this debate were not harmed. If anything, they were actually benefited. We then spoke about the environment. We gave you an example. The opposition's response was, this was criminal, and secondly, we still have class actions. We told you two things. Firstly, no, it could be civil because you could sue for non-enforcement of environmental regulations. Secondly, we told you it was always better to limit the complexity of things. Lastly, the opposition told us prosecutors will leave the DPP. We told you that crime again fell out of this debate, and we told you that this already happened if they care about money. At the end of this debate, we thought it was principally justified that if people were suffering within a civil claim, that they should have access to recourse, and that the only benefits that would happen were going to be good ones. We won this debate.